are, on the plain face of it, anti-competitive. The whole point of these agreements is to prevent businesses from having to compete for workers. It's like price fixing, but for jobs. Bipartisan coalitions in Congress have supported restricting non-compete clauses. And that's why I was really pleased in April when the Federal Trade Commission finalized a new rule to protect more than 100 million workers by prohibiting employers from forcing their workers into non-compete agreements. This rule is another example of the Biden-Harris administration acting to rein in corporate abuse, and it makes lives better for ordinary Americans, from reducing abusive overdraft costs to ensuring workers get the overtime pay they deserve, to wiping out junk fees on airlines, concert tickets, hotels, and more. Now, with this rule, the FTC is doing exactly what Congress authorized it to do, prohibiting unfair methods of competition. This rule is incredibly popular. More than 90% of the comments that the FTC received on the rule were favorable, and it's no wonder. FTC analysis shows that it will increase workers' pay by an average of about $500 a year. It will cut health care costs by tens of billions of dollars over the next decade. The rule will unleash innovation and economic growth, helping create about 8,500 new businesses every year and resulting in tens of thousands of new patents. The FTC and the Biden-Harris administration deserve all the credit in the world for putting this rule in place. You've heard me say it before, and I will say it again. I believe in markets, competitive markets. This rule makes sure that Americans can take their skills, their labor, and their willingness to work hard into that market and get the best possible pay and working conditions. That's how markets are supposed to work in a free country. So, where are our Republican friends on this issue? Once again, instead of standing up for real competition, they are moving nearly in lockstep with the big corporations that hate these rules. Republicans in the House have introduced a Congressional Review Act resolution to try to overturn the FTC's new non-compete rule. Of course, if it managed to pass the House and the Senate, President Biden would veto it. So opponents of the bill are now taking to the courts, and they are getting President Trump's judges to intervene on this rule. The Chamber of Commerce and other corporate trade groups have gone court shopping to put the case before an extremist, Trump-appointed judge in Texas, and they're hoping to get an extremist ruling next month to put the whole rule on hold. These lawsuits are the product of an abuse of the justice system to try to stop the Biden-Harris administration from helping America's workers. The opponents of the rule are going so far that they are even trying to have the FTC, after all these years, have the FTC declared unconstitutional. This is not the first time that the Chamber of Commerce and other big money outfits have trotted out this playbook. This is what happens when big business thinks it can get whatever it wants from radical Trump judges. They use the courts to block the Biden-Harris administration from enacting common sense rules that will help Americans and help our economy. We need to deal with this specific case on non-compete clauses, but we also need broader court reform to end these abuses. As this case in Texas moves forward, another judge in Pennsylvania has refused to strike down the FTC's non-compete rule. The Texas case should be resolved similarly. Any reasonable, nonpartisan interpretation of the law would make it clear that Congress explicitly gave the FTC the authority to ban non-competitive restraints of trade, including non-compete agreements that keep workers from looking for a better job. In today's hearing, we'll hear more about why the legal effort to roll back this rule is wrong and about how, once the rule is finally implemented, millions of workers will benefit. With that, I turn to my ranking member, Senator Kennedy, and ask him for his opening statement.
Thank you, Madam Chair. Welcome to our witnesses. About 90% of my personal and political philosophy is don't hurt anyone else unless you have to defend yourself. Don't take other people's stuff. And leave me alone. I believe in free enterprise. I believe in markets. I believe in the ingenuity and the persistence of the American people, of all people, humanity. Non-compete clauses are sort of like Senate bills. There's some good ones and there are some bad ones. Non-compete clauses, by their definition, are a restriction, operate as a restriction on both the employer and the employee. So from one perspective, there are restrictions on free enterprise. That doesn't mean that they're inappropriate in all cases. When it's necessary to protect business information, when it is necessary to protect trade secrets, when those agreements are negotiated by two parties of reasonably equal bargaining strength, there can be a place for non-compete agreements. They can also be abused. I don't think it's appropriate for example, a fast food restaurateur. I don't know if this example even exists, but I've heard some people allege it. Shame on them if it's not true. But if it is true, I don't think a fast food restaurateur should ask entry-level employees to sign a non-compete agreement. Then what's the point other than to restrict free enterprise? That makes no sense to me. I think it's also very important for us and for the courts to take a look at the bargaining strengths, relative bargaining strength of the parties. I don't believe in contracts of adhesion. I think that people ought to, all things being equal, ought to be able to address these issues with the same amount of leverage. Now, we live in the real world. I know that balance doesn't always exist, but it's something that we have to take a look at. Most state law, of which I'm aware, requires that non-compete agreements be reasonable. And courts, I think, at both the state, to some extent at the federal level, but generally it's a state issue, take a look at the length of the non-compete agreement. They look at the bargaining strength of the parties. They look at the terms, obviously. They look at what behavior is being restrained. Why is it necessary to restrain that behavior? What are the interests of the employee? What are the interests of the employer? And if they're reasonable and there's a legitimate purpose, I think in most cases they've, let me say this, in many cases they've been upheld. I'm going to stay as long as I can today. I'd like to hear your testimony. I'd like to ask you questions. We've got a lot going on. I think a vote has already been called, and I'm going to have to go down and vote. But what my friend Senator Warren said in her opening statement, notwithstanding about Republicans, that's kind of this Republican's point of view about non-compete agreements. Okay, thank you.
Thank you, Senator Kennedy. And now I'd like to introduce our witnesses. First, we have Dr. Heidi Shearholtz. Dr. Shearholtz is the president of the Economic Policy Institute. She served as the chief economist at the U.S. Department of Labor during the Obama administration. Thank you for being here with us. Next is Dr. R. James Toussaint. Dr. Toussaint is an orthopedic surgeon who completed his medical training at NYU and Harvard University. He currently practices in Florida. I want to extend a very special thanks to Dr. Toussaint because he was one of the people who helped during the Boston Marathon bombing, and we're grateful for that help. I also want to extend another very special thank you. I know that you were very helpful following the earthquake in Haiti in 2010, so thank you very much for your work. And our third witness is Ms. Haley Page. Ms. Page is a wedding and shoe designer who also resides in Florida. She rose to fame designing Haley Page dresses sold across the country and starring on the TLC show Say Yes to the Dress before being slammed with a non-compete that she only very recently beat in court. So thank you very much for being here. So I'm going to start, we'll do witness statements, and then we'll go to our questions. Dr. Shearholtz, if I could start with you, please.
Thank you very much. Chair Warren, Ranking Member Kennedy, other members of the subcommittee, thanks for the opportunity to testify here today. So first, non-compete agreements are ubiquitous. Most studies find that roughly 1 in 5 workers are subject to a non-compete, and without a ban, that share would almost surely keep rising. To understand the effect of non-competes on workers, it's useful to remember that essentially the only source of leverage that an individual non-unionized worker has with respect to their employer is their ability to quit and take a job somewhere else. That is the thing that means their employer has to provide them a job that is competitive enough in terms of compensation and opportunities that they're not incentivized to leave and take another job or start their own business. But non-competes cut off that source of worker leverage at the knees. When workers do not have the freedom to take another job, their employers simply do not have to pay them as well or provide them as good a job. And an extensive body of research bears that out, showing that non-competes significantly reduce wages. Okay, some claim that though non-competes reduce wages, they're still necessary because they say they boost innovation by incentivizing firms to invest in developing important advancements. However, the best evidence consistently finds that the net effects of non-competes on innovation go in the opposite direction. Here's why. By preventing workers from leaving their employers to create new businesses, non-competes reduce business formation, reducing dynamism in the economy. And by keeping workers locked in jobs, non-competes reduce productivity growth. The economy runs the strongest when workers are in the jobs that are the best match for their skills and interests. Non-competes keep workers from being able to go to firms that yield the most productive matches. The declines in non-competes in business formation and job-to-job mobility cause an overall decline in innovation. So, for example, studies consistently find that non-competes lead to significant decline in the rate of patenting, including in the rate of breakthrough inventions. Okay, further, banning non-competes will likely reduce inflation. Non-competes increase concentration in markets for goods and services by preventing workers from leaving their employers to create a new business or to join other firms that would intensify competition, and all of that increases prices. So, for example, research shows that non-competes significantly increase the cost of physician services. Banning non-competes is estimated to reduce healthcare costs by at least $74 billion over the next 10 years. It is also worth noting that employers do not actually need non-competes to protect trade secrets. Intellectual property law provides businesses with significant legal protections for trade secrets, and employers are also able to use tailored non-disclosure and non-solicitation agreements. Provisions like those that directly address what employers may and may not do with company secrets allow businesses to protect trade secrets without being such a blunt instrument that they harm competition by taking away workers' freedom to take another job at another firm or start another business if they leave their firm. Okay, some have claimed that the FTC does not have the authority to ban non-competes, but the FTC Act clearly states that unfair methods of competition are illegal, and it authorizes the FTC to issue rules and regulations that prevent their use. And I think it's worth stepping back and just noticing non-competes are not trying to hide that they are contrary to open and fair competition. It is in their name. With the non-compete rule, the FTC is doing exactly what it was empowered and directed to do by the FTC Act: take action to protect fair competition. Finally, I'll say it's worth considering who benefits from non-competes. Non-competes benefit the owners of existing businesses who want to protect their advantage by stopping new businesses from forming and competing with them. They also benefit existing businesses who want to pay their workers less and prevent other firms from being able to hire them away by offering them better jobs with better wages. So it is not actually surprising that groups representing incumbent business owners are fighting tooth and nail to keep their non-competes, but that does not mean non-competes are good for the country. They aren't. They are bad for the vast majority. They are bad for economic dynamism and innovation. They depress business formation and labor mobility. They hurt productivity and growth. They raise wages. They raise prices. They shrink workers' wages. They restrict workers' freedoms. Banning these coercive and unfair agreements is fundamental to the FTC's mandate, and the workforce, consumers, and the broader economy will be better off for it.
Thank you very much, Dr. Schierholtz. Appreciate your testimony. Dr. Toussaint.
Good afternoon, Chair Warren, Ranking Member Kennedy, and members of the committee. It's an honor to be here, and I thank you for inviting me to discuss my experience with non-compete agreements from a doctor's perspective. My name is Will James Toussaint, and I'm an orthopedic surgeon at the University of Florida as of 2022. And I'd like to state for the record that the opinions expressed herein are my own and do not reflect the positions of UF or UF Health. I was born in Haiti and immigrated to Florida, where I achieved the American dream. I was the first in my family to be accepted to college. I worked on Wall Street after college to pay off my student loans. I was then accepted to medical school, where I graduated among the top of my class, and as a result, I matched at Harvard University's orthopedic surgery residency program and then completed an orthopedic foot and ankle fellowship. In 2014, I joined a private practice group in North Central Florida as their only foot and ankle trained orthopedic surgeon. I was one of only 2 surgeons with this expertise across a dozen mostly rural counties serving over 850,000 people. Over the next few years, my partners and I felt the pressures of decreasing reimbursement coupled with the burdens of pre-approval requirements from insurers and competition from other practices. We felt that an infusion of capital was necessary to remain sustainable. As a result, we entered into a purchase agreement with a private equity company headquartered in California. The deal closed in 2017. Although I cannot disclose the transaction's details, there was indeed a non-compete clause. Per the non-compete clause, I would be restricted from practicing orthopedic surgery within 25 miles of any facility in which the group was currently providing medical services, any facility in which the group had previously provided medical services, any facility in which the group was targeted for expansion within the entire state of Florida, and any facility the group was in discussions with related to a potential acquisition. This non-compete was valid for 2 years, and of course, the group was located in multiple states. One might wonder why we would sign such a deal. The reality is that the nuances of the non-compete were not known until we, the doctors, spent hundreds of thousands of dollars in transaction expenses related to the acquisition. We felt backed into a corner and believed that our only choice was to proceed with the transaction in good faith. Unfortunately, within months after closing the deal, the morale of the physicians and the staff declined. Instead of cost savings, the practice's overhead expenses increased significantly due to more layers of administrators, excessive management fees, and millions of dollars of debt expenses. The overhead increased so substantially that some physicians not only did not receive a paycheck, but actually paid to work, despite the physicians taking on all the risks of patient care. All the while, the cost of the patients started to rise, and they complained that their quality of care decreased. Personally, I became disillusioned by management's focus on dollars instead of the quality of care. I eventually put in my resignation stating my intent to leave for academic practice at the nearby nonprofit public institution. This decision made sense given that the only other orthopedic foot and ankle surgeon in the entire region was retiring, and I would be able to help educate the next generation of doctors. Despite this, the private equity group filed suit against me. It did not matter to the private equity group, that a community of over 850,000 people would not have a specialist surgeon to care for them. It also didn't matter to the private equity group that the university was the only contracted provider of orthopedic care for Medicaid patients in the community, and without me, they would have to travel hours away for care. And finally, it did not matter to the PE group that the state of Florida had already enacted a special statute, Chapter 542, Section 336, stating that if one entity employs all the doctors within a special specialty in the county, that the non-compete is already void. It didn't matter to them. Despite all of this, within days of my leaving the practice, the private equity group threatened legal action to prevent me from entering academic practice. Despite the aforementioned Florida statute negating the non-compete, the private equity goals were clear: to wage a prolonged legal battle in the hopes that I would give up and leave my community before a final judgment was made. After an expensive 4-month dispute, a legal settlement was finally achieved and I was able to join the university. Not surprisingly, many patients from my previous practice told me that they were very frustrated when they called the group asking for me. They said that the private equity group lied to them and stated that I had retired from medicine, which is clearly untrue. Because of my concerns with private equity in healthcare, including their use of non-compete agreements, I joined the Coalition for Patient-Centered Care, a group of healthcare stakeholders who oppose private equity's influence over independent physicians. I have experienced the negative consequences of non-compete agreements have on patients, the physicians, and their communities. And I conclude that these restrictive covenants negatively impact patient access to physicians, limit the quality of care, and increase costs to all parties. Thank you.
Thank you, Dr. Toussaint, and I very much appreciate your coming here to share your story. Ms. Haley Page, you're up next.
Good afternoon, everyone. This is such an honor. Thank you so much for having me. I love my country. I am somebody that knew what I wanted to do at a very young age in life, and I dedicated my childhood, education, and industry experience to bringing women joy through wedding dress design. And boy, did I love it. My dresses were in over 300 stores. I was on a show called Say Yes to the Dress. And at one point, Vogue actually named me one of the top 10 wedding dress designers in the world. So this was my dazzling American dream. However, my non-compete clause. This stifled my ability to work, took away what I loved doing most. It left me financially devastated, and it shook my faith in the justice system. Let me take you back to how it started. In 2011, at 25 years old, I signed an employment agreement that included a non-compete clause, as well as an intellectual property provision. I believed that this non-compete was reasonably restricted within the duration or term of my employment. It would be perfectly reasonable to not compete with the very company that I was trying to add value to. But there was also a disproportionate negotiation power that many young employees and young creators are subjected to. I felt compelled to sign that contract or I would lose my big opportunity. 9 years later, thousands of dresses, I attempted to renegotiate that contract as I felt I had outperformed. My contract was due for a good upgrade. My former employer sued me in federal court, and it was only then that I realized exactly how that contract was going to be interpreted. Under a subsequent injunction, I was forbidden from using my own birth name. I was also not allowed to practice my chosen trade for a 7-year period, unpaid, no commission, no royalties. I also had to hand over my heavily followed and personal social media accounts. It dawned on me that securing my dream job at 25 years old actually required me to forfeit that dream once that job was over. Now, I refused to succumb to victimhood entirely. I chose a creative pivot. I changed my name publicly to Cheval, and I started a new Instagram. But the idea of having to change my trade after I dedicated my life to a very specific skill set, where all of a sudden it felt like my livelihood became a threat to others, was the hardest thing of everything that happened to me. Even not being able to use my birth name, it was still worse to not be able to practice my trade. So I think you can imagine what happened next. I fought. 3.5 years of litigation, millions of dollars that I didn't even have. I am now in debt. I spent every dollar I ever made designing wedding dresses to fight for my right to once again design wedding dresses. I was privileged to have a devoted and incredible legal team that went to bat for me when my financial situation ran out. Most people do not have this privilege. It took us 2 trips to the appellate court just to get my Instagram back and prove that it was mine. Now, the residual stress on brides was devastating for me. I'm very close with many of my brides, and they dreamed of this moment for years, to pick the dress of their dreams from their favorite designer, and they no longer could. I also experienced residual stress from my store base, who invested in a designer brand from a very specific designer. In my mind, my contract did not benefit me, my brides, or my industry. It also didn't seem to impact positively my former employer, who filed for bankruptcy during the litigation. The American dream is built on the premise of what you can do for your country. What is your contribution? And if we want to continue to inspire innovation, tax people the way that we do, and assure that opportunities remain accessible, we cannot restrict people from working. If corporations are not limited in hiring and profiting, why are employees limited or restricted on working and earning? In my situation, I was replaced by another designer in a matter of months, yet I couldn't make a living for years. Now, I know this testimony is from the perspective of an employee, but I am now also a small business owner. And what I've learned is that there are very effective legal precautions you can take to protect your intellectual property. I now officially own my own, and I know why it is so important. There are privacy policies, fiduciary duties. There are also ways to impose non-disclosure agreements to effectively safeguard trade secrets. Imagine a world where the next great innovation is unrealized, where the brightest minds are not in laboratories or hospitals or sitting here in this courtroom. Just imagine what we could be missing out on. The irony is that this hearing is taking place in one of the best days of competition in the world, the women's gymnastics team finals in the Olympics. I was a competitive gymnast for 16 years, so you can only imagine the poetry that I am experiencing right now in this very moment. But I can tell you firsthand that the pride and the patriotism that you can feel when you have no cap on what you're capable of doing, that is where the magic is, and that is where I believe our country goes. So to that, long live fair competition, and let the girl design a dress.
Thank you very much, Ms. Page. That was very powerful. I recognize Senator Smith from Minnesota to start our questions.
Thank you very much, Chair Warren and Ranking Member Kennedy, and thank you so much to our testifiers here today. I am really grateful for your testimony. So I am very glad to see the FTC rule on non-competes, and I think the stories that you told, Dr. Toussaint and Ms. Haley Page, really demonstrated. To think that with these non-competes, you would lose not only your livelihood, but even your identity because you're sort of trapped in this agreement that in many cases I hear over and over again, people don't even really understand what it is that they're signing and what long-term implications it has. I want to just turn first to Dr. Scherholz. Could you, as I understand it, as you testified, 1 in 5 workers in this country have been covered by non-competes. Why is it important that the FTC rule covers such a very broad range of workers? Because I think maybe most Americans can sort of understand that if you were like a top-notch scientist working for a big company, that you shouldn't be able to take that, those trade secrets and go to another company. But that's not what we're talking about here, is it?
Oh, is this on? This is on.
Yeah.
So non-competes, the evidence shows that they are not just applying to people that are high, who make high wages, who may be the ones that are most likely to have access to trade secrets, that they really are even prevalent among very low wage workers. Like there's one study that shows that the median person who's affected by a non-compete is an hourly worker who makes $14 an hour. So they really do run the gamut. And then the other thing is, it's really important to ban non-competes, though, across the board, not just for low-wage workers, but across the board. And one of the reasons is higher wage workers, they're the ones who are actually in the position to be the most likely to actually be able to negotiate. They're not the 25-year-old, right? Like they can potentially negotiate over their full employment package, including restrictive covenants like non-compete. So I'm less worried about the wage suppressing effects from non-competes among high wage workers, but I'm deeply worried about the other economic harms from non-competes amongst high wage workers. Reducing business formation, declines in productivity, declines in innovation, increases in prices. So it is incredibly important when we think about the broader economic impact that we have this very broad ban of non-compete.
So I want to get to sort of follow up on that because I think we could hear from Dr. Toussaint and Ms. Haley Page about the kind of the impact that this had on them. And I'm thinking about my home state of Minnesota. In 2023, the state passed a legislation to ban new non-compete clauses in employment agreements. And with that action, they became the fourth state to prohibit these clauses, a very important step forward. Interestingly, the Minneapolis Fed says, as you were testifying, they expect that this change will support worker mobility and also yield other economic benefits, as we've been talking about. But what was really interesting is as they talked with lower and middle wage workers, so maybe people just getting started out, people who were not at the senior executive level, who had worked under non-competes, here's what they found. That the stress and anxiety were common experiences for workers as they struggled to kind of figure out come to terms with what they had agreed to. There's a really interesting example of that with a cosmetologist. Cosmetologist leaves her employer. She was very careful not to tell her old clients that she was leaving and nor where she was going to work next. She was told, like, you can't even accept those clients. Again, unless you're providing a different service, like you're doing their hair instead of doing their makeup. And so some of those clients came to her, and then her previous employer reaches out to her and says, hey, stop it. You can't do any work for any of those people at all going forward. And of course, this creates huge worry and anxiety for her. I mean, how common do you see, I mean, this is maybe for any of you, how common do you think it is, this sort of level of intense worry and anxiety that this cosmetologist experienced, according to the Minneapolis Fed?
I'm happy to go first. I will. So it's very, very common. And one of the things that sort of underscores this is that non-competes actually have a chilling effect on worker mobility, on business formation, even in states where they are not enforceable. Mm-hmm. The very existence of a non-compete actually deters workers from leaving a job, from forming a new business. You just
don't feel like you have as much
for the reason that you said, right? Like litigation is incredibly expensive, and both financially and otherwise, and it has just the threat of that is actually what businesses use to enforce their non-competes, right? Rather than lawsuits themselves.
Thank you. I know I'm out of time, Mr. Chair.
Thanks, Tim. Thanks, Tim. Dr. Toussaint, you're an orthopedic surgeon, is that right?
That is correct.
Okay. Where'd you go to med school?
I went to medical school at NYU, sir.
Okay. And I think you said you were at the top of your class.
Yes, sir.
And then you trained at Harvard.
That is correct.
And then you joined other orthopods in a practice, right?
That is correct.
How many orthopedic surgeons were in your class? Were in your practice, rather?
I don't recall the number of orthopedic surgeons specifically, but there were approximately 25 partners within the group.
And you were a partner?
Yes, sir.
Okay. And a private equity company came in and said they wanted to buy you. Is that right?
That is correct.
And you and your partner sold, right?
That is correct.
And they paid you a bunch of money, right?
They paid me some money, sir. That is correct.
Yeah. How much did you walk away with?
I walked away with nothing.
No, when they bought your practice, you were a partner. You were paid, right?
Right at that point, sir, I did not walk away, but I was.
Well, I didn't strike the walk away. How much did you personally gain from the sale to the private equity group?
I'm not allowed to disclose the details of the transaction, sir.
Was it over? Why not?
Because that is part of the transaction's restrictive agreement, sir.
Was it over $1 million?
I'm not allowed to say, sir.
Was it over $2 million?
I'm not allowed to say the amount.
It was a
sir.
lot of money, though, wasn't it?
I do not believe it was worth my freedom, sir.
But you did at the time.
I did not, sir.
Okay. Why'd you sign the agreement?
Because it was, for the lack of a better term, I was compelled to sign the agreement in order to fall in line with the group, sir.
Here's why I think you signed the agreement, and I don't mean to offend you.
It's okay.
I've seen these kind of transactions before. This is going on all over the country.
That is correct.
I think the private equity group came in and offered you and your partners a huge sum of money in the millions. And I think you took it. And I think later you regretted it. And you wanted out of the deal. And I think that's violates the freedom of contract. And I will bet, no offense, doctor, but I will bet that you wouldn't be willing to give back the millions of dollars that you took away from the sale in order to get back your freedom to practice.
Can I respond?
Sure.
If I may respond, thank you for the opportunity to respond to your question, sir. I have to say that, number one, I was not in favor of the sale. That's number one. And then number two, I have to disagree with your final statement without giving away any details. But I can say in my personal experience that is false, sir.
Okay. You took the money, though, didn't you?
The thing that I disagree with, sir, is whether or not I gave it back.
Yeah, but did you take the money?
I gave it back, sir.
You gave back all the money that the private equity group paid you.
As part of the
Is that your testimony?
as part of the settlement, I have to say that I had to buy out of the non-compete.
Yeah, I don't want to play games, Doc, but
Yes, sir.
when the private equity guys came in and said, we want to buy you out, you might have disagreed with your partners, but it sounds like they outvoted you.
That's correct.
You could have left the practice then. You chose not to. You chose to take the money, did you not?
If I chose to leave the practice, sir, I would have had to leave
I understand.
the state.
I get that. But you took the money, did you not?
Yes.
Okay, thank you. Doctor, let's suppose that Elon Musk decided to leave Tesla. General Motors hired him away. Said, we'll pay you $50 billion a year because we, General Motors, are sucking wind. And they are. But if we sign you up, we want an employment contract, and we're going to show you all our intellectual property. And we're going to insist that you sign a non-compete agreement. Now, you got General Motors, you got Elon Musk, one of the wealthiest, if not the wealthiest, people in the world. Why should those two not be allowed to negotiate an employment contract, including a non-compete agreement?
As I explained to Ms. Smith, I'm less worried about wage suppressing effects of non-competes on very high wage workers. Obviously, Elon Musk would be able to negotiate a non-compete with a new employer. He
Would
has
you have
incredible.
any problem saying that's okay?
There are other options for
Yeah, but would you have a
GM.
problem?
I would have a deep problem with saying that's okay, because what we're
You're
talking,
just against all non-competes.
because of their effects on the economy, their effects on, negative effects on workers, negative effects on consumers, and negative effects on the economy more broadly.
I just don't think you're very objective. I don't think you're a very objective witness. It's been my experience that most of these issues, there are always two sides. And no offense, you're entitled to your opinion. I enjoyed listening to you, but I can tell from your breathless presentation that you just feel passionately about this, and I respect that, but I think you're kind of blinded by your ideology. That's just my point of view. But I thank you for being here. And I went way over. Give Tina more time. Because she stayed within her limits, and I went way over. And I got to go vote.
All right. Thank you. So nearly 30 million people, as you talked about, Dr. Sherholtz, since I tend to think you are driven by data, and that's what's important here, are trapped in non-compete agreements. Corporations use non-compete agreements to hold workers hostage. It prevents them from either starting a competing business or going to work for another employer. So a worker who has a non-compete faces two bad options: stay stuck in a job that you really want to leave, or upend your life to break free from the non-compete by moving away from your current job, changing your career, leaving the workforce, or risking an expensive years-long battle in court. I believe that workers should have the freedom to switch jobs. They should be able to seek higher wages, better working conditions, and if they so choose, to start their own businesses. But big businesses want to control workers and stifle competition, even if it hurts our economy as a whole. Dr. Toussaint, if you had to sign a non-compete agreement when your medical practice was bought by a private equity company, and can you just say a little more? You talked about this a bit in your opening statement, but how broad this was. This was not a non-compete that said you can't go right next door and open the same practice under almost the same name. How broad was your non-compete? What all did it cover?
Thank you for the question. It's important to note that the private equity group at the time was located in 3 states: Colorado, Arizona, and Florida. My non-compete specifically said that I would be restricted from practicing orthopedic surgery within 25 miles of any facility in which they are doing business, any facility that they had previously done any business, any facility that they are currently targeting for expansion within the entire state that I am currently living in, which is Florida, and then any facility that they have had discussions with in thinking of acquiring in the future. And this would be valid for approximately 2 years. So we're talking 3 states, and in my specific location, at the time I was one of 2 surgeons covering specialized treatment for over 850,000 people, most of which are within rural counties. Okay. I thought that was insane.
All right. So they have barred you basically from practicing medicine in any of these 3 states. And I detect from the way they wrote it, in case they were thinking about any other states, you would also be covered in those. But I take it was more than just a prohibition on going into private practice. When you were offered a job at a publicly funded academic hospital, what happened? Can you say again about what happened when you tried to accept that job?
Right. Unfortunately, as part of their agreement, they wanted me to give a copy of the employment agreement and non-compete clause to every employer that I was having a discussion with. So that's essentially like a scarlet letter or basically a mark against me to say that if you want to hire this doctor, despite his specialized training, you're going to have to go through us. And we are in multiple areas across the United States.
Right. And so now let's talk about what go through us turned out to mean. In fact, you were able to go become a teacher of other doctors, which is obviously not a direct competition originally. So calling this a non-compete, it shows how much it is stretched out in terms of how much it restricts you from doing. But what was the consequence of the you have to go through us part of this contract? How did you ultimately end up going to work for the university?
Thankfully, the university and the community needed me more than they wanted me out of town. I unfortunately had to engage a number of community leaders, including the NAACP, and a lot of my patients to go and support me in this effort to be able to work. If I didn't do that, I would have to relocate out of the state, and I would have missed out on a number of collaborations within the university.
You know, I just want to say, we talk about what happens to an employee who's stuck in one of these non-competes, but you have given us a perfect example of how those non-competes end up hurting communities, in your case, end up hurting patients, others that you serve. And in this case, I just want to underscore, communities are served now by the more than 37% of physicians across this country who are currently bound by non-competes. So unless you go through the person who owns that contract, these are whole communities that could lose access to the physicians that have served them so well. So you had folks on your side who were able to weigh in so that you ultimately were able to go to the university. Ms. Page, let me turn to you. Your former employer used a non-compete to keep you from designing wedding dresses, whether it was under your name or some other name. Can you just say something about what that meant both for you and for your brides?
Thank you for your question, Senator Warren. It was devastating and disheartening. I am in an industry that relies on an emotional purchase, and there is an authentic connection made when saying yes to the dress. And to have that tarnished or severed is almost as if we're putting a veil over what's really happening. And in my experience, it was truly difficult to imagine how you could communicate and make that connection to a bride if not only I couldn't express myself creatively in the way that I thought I could, but I couldn't even use my name or practice the trade. Mm-hmm. It was interesting, I think, too, from the business perspective, because we are a wholesale business and all of these stores had invested specifically in a designer collection. And so when the designer was no longer behind the dresses, they were affected. They felt the residual stress of, how do I explain to the consumer and the brides coming in the doors that this dress no longer has the Haley Page behind it? Mm-hmm. And obviously, when you invest that kind of money in your business and you're unable to sell the merchandise or feel ethically icky in doing so, it creates a really big void in the marketplace.
Right. So hard on patients, hard on brides, hard on the other small businesses that have built up around you and your brand, wanting to sell those Haley Page gowns. Can you just say one more word about it, though? I thought about when I first heard about your story, what it must feel like if you're a pianist and you're not allowed to play the piano, if you're a painter and you're not allowed to paint, if you're a wedding gown designer and you have been told you cannot make wedding gowns. There are other things you can do in life, but that has been crossed off your list for years. Can you just say a little bit about how that feels?
Yes, thank you for your question, Senator Warren. It was soul-crushing, but what's interesting about my case is that it was challenging my identity from 3 different factors. I was unable to use my birth name, I was severed connection to my social media community, and I was withheld from my trade. Of all 3 of those things that are extremely hard to wrestle with and digest, not being able to practice my trade was the most emotional and hard to overcome. And in that moment, I had realized how much of my identity came from my craft. And I think when you devote yourself to a craft, part of you becomes that craft. And it really did feel like a severing of who I was. And I'm so grateful, of course, for the support I received. But it was also particularly devastating to feel the confidence and the height I was at in my career. Not very many people can perform at that level. And that is something that should be celebrated. And as a woman who struggles with insecurity, to feel like you're really good at something, but you're not allowed to do it. And then you have these amazing women that want to see you do it, but then you can't deliver. It's emotional and devastating.
So, Dr. Sherholtz, you've just heard from two people who have lived through experiences with non-competes. Each of them have fought back, and they have mustered communities around them and been able to hit back. But talk just a little bit about the effect of these non-competes across our economy.
Yep. Yeah, the things that Ms. Page and Dr. Toussaint experienced, they're just all too common. Non-competes restrict workers' ability for starting a business, for practicing their craft in their community, for taking another job in their community. And economy-wide, when you put the data to it, what you find is that reduces business formation, it reduces worker mobility, and then those things reduce productivity, they reduce innovation, they increase prices, and they reduce workers' wages. So we can see how this played out in these folks' lives. And then when you look more broadly at the economy, it's just incredibly harmful on all measures.
Well, I'm very grateful to you two for telling your stories, and very grateful to you, Dr. Sherholtz, for just describing and putting the context all across our economy. The Biden-Harris administration has taken historic action to ban non-compete agreements. And right now, it is fighting back against the Chamber of Commerce and these giant corporations that continue every day to profit off non-compete agreements. Now, one of the things I want us to turn to now, I'm just going to give myself a second round of questions here since I don't have anyone competing with me for this time. I want to talk about what the Biden-Harris administration is doing here and how it is a game changer to ban non-competes. By giving workers the freedom to move jobs and to start new businesses, employers are going to have to change what they do. They're going to actually have to compete for workers. Workers' earnings, we believe, will increase collectively by about $400 billion over the next decade, according to the FTC. A typical worker, it would be about $500 more that worker could take on. And the American economy will be more dynamic and innovative, with about 8,500 more new businesses and tens of thousands more new patents if people can get out of these non-competes and go out and either start their own businesses or go into business with someone else or work for someone else. We get this massive economic boom because the FTC has designed the ban to be extremely simple. It says no new non-competes at all. It's not fussy, it's not fancy, none. Existing non-competes can be enforced only for the most senior executives. So, good for workers, good for the economy, but big corporations are unhappy about this rule. So what they say is they could do a rule, but they want a rule that is narrower and more complex. More like Senator Kennedy was talking about on, well, maybe a case here, maybe a case there, but a lot of very complex rules about how to make that work. Dr. Toussaint, you struggled with a non-compete agreement in Florida, where you live, but Florida already has a law that says a doctor cannot be bound by a non-compete if, in their county, all the doctors in their specialty work for the same employer. So I can't think of a law more specifically designed to address your specific issue. Why didn't that law just permit you to get out of your non-compete without Any further question?
Thank you for the question. Number one, it's important to realize that this private equity company was not based in Florida, and their tactic is to file suit outside of their jurisdiction and outside of my own jurisdiction. So the plan is to wage a suit away from where we both live and make it as long and as expensive as possible, to the extent that I would give up and I would walk away before a judgment is even rendered. And so a scenario like that, you could imagine that the doctor's resources would not be as sufficient as the private equity firm's resources, and they could run it dry. Even though eventually I might win, it's unclear if I would even last that long.
So part of the problem we've got here then is the litigation itself is expensive, and they have found ways to make it even more expensive. I take it, Ms. Page, that was what you ran into?
Precisely.
Yeah, just drive up the costs and grind you down into the dirt. So the threat of the non-compete is big and important. It's also a question of who's going to be on your side to fight this. Who had to pay your legal bills, Ms. Page? Who was there?
Unfortunately, I tapped out.
Yeah, it's you, right?
Yes.
And Dr. Toussaint?
Same here.
You had to bear your own legal bills. So what the FTC has said is we're going to have a very simple rule. It's going to be a nationwide rule. You don't get to go sue in some other state and think you can avoid some local rule. But it's also the case that the FTC can enforce it as an unfair practice, which means instead of being out there all by yourself, you will actually have someone on your side. That's the idea behind this. Yes, I see you smiling, Dr. Toussaint. That sounds like a good thing. You know, I want to point out one more thing before we leave this, and that is that the FTC's non-compete ban is very popular. Polls show that an overwhelming proportion of Americans and a majority of small business owners support the FTC's rule. In fact, as you know, when the FTC is about to put a rule in place, it's still a proposed rule, they invite public comment. They got 25,000 comments on the non-compete rule. And I just want to say, not everybody sits around in the evening and says, what can we do tonight? I know, let's go do a non-compete rule comment on the FTC website. Of those 25,000 comments, 24,000 came from individuals and businesses who said, we want to have meaningful non-compete clauses. This is valuable to us. And many, many people went on the FTC website to tell their own stories, very much like yours, Ms. Page, very much like yours, Dr. Toussaint, to talk about just how challenging it was when they got hit with a non-compete and how many people just gave up. They did not have the money for lawyers. They simply could not go forward, so they stayed in really horrible jobs. At this point, I'm going to pause and see if Senator Van Hollen would like to ask some questions. Would you like to do that? Thank you, good. Senator Van Hollen.
Thank you, Madam Chair, and thank you for holding this hearing. Thank all of you for your testimony. As you know, we're bouncing back and forth between hearings, but I'm really grateful for all of you being here to tell your stories. And I do want to recognize the good work of FTC Chair Lena Khan and her leadership in advancing the rules to address the issue of these non-compete agreements, because I think all of us recognize that the original idea behind non-compete agreements was people have really the crown jewels, the secrets, right, of a particular company, and they weren't. You sign an agreement to make sure that you can't use that intellectual property, so to speak, in another job. But now we find out that 30% of non-compete agreements affect workers earning less than $13 an hour and go way beyond what was ever intended for non-compete agreements. So, Dr. Shearholtz, I'd like, if you could, to talk a little bit about how non-compete agreements affect workers who are just starting out in their careers, right? This is impacting individuals at young ages and inhibiting their ability in many ways to go up the career ladder and find new opportunities. Could you just talk broadly about that?
I can. Haley's example is the perfect example of how these can just lock in young people. But what we do know is that banning non-competes will raise the lifetime earnings of young workers by raising their wages and by reducing prices. And I do want to just say that some people will claim that without non-competes, businesses won't do training, and then that will reduce the that will have negative long-term wage effects. So the evidence shows that that is not true. There's good studies showing that people who start a job in a state that strongly enforces non-competes have reduced earnings for more than 8 years compared to other workers. So there's offsetting factors, but on net, workers, and that goes for young workers as well, are made worse off by non-compete agreements.
Well, thank you for that. And Dr. Toussaint, again, apologize that this has already been covered. I was reading about your story and your personal experience as a physician subject to a non-compete agreement. Obviously, that has a harmful impact on physicians, but it also, of course, has a harmful impact on all the patients who don't have access to the services of physicians and that like you. So could you just talk a little bit about how these non-compete agreements interfere with a patient's ability to get care and the continuum of care that they need?
Thank you for the question, Mr. Van Hollen. It's fair to say that patients follow their physicians. They don't follow the company name or the clinic's brand. They follow the doctor. I was one of 2 subspecialist orthopedic surgeons in an area of northern Florida where 850,000 people needed to be served. If I was driven away and the other surgeon was left, and by the way, this other surgeon was nearing retirement, we would have had 850,000 people without a subspecialist to treat them. They would have to travel hours away to get their care. They did not come to see me because I was under the umbrella of a private equity company. And in fact, the private equity company was not even in the area. They're not even in the state. They were there for me. And so if I would have had to leave, these patients would have had no one to care for them. I look forward to a federal ban on these non-competes because it does impact the patient's ability to get care. It impacts my ability to care for my patients and to live in an area that I have grown and loved. And ultimately, it raises the costs for everyone. And I think that this needs to be addressed.
Thank you. Thank you for addressing both the direct access of care to specialists that people need, and then obviously in the impact on costs. Ms. Page, in our remaining time, I had a little bit of a chance to review your case in the lawsuit, and really outrageous what happened, but also a very good example to bring before the committee. And you've probably covered this with respect to your specific case, but could you also talk about how the non-compete agreements, like the kind that attempted to restrict you in the lawsuit, threaten the ability of young entrepreneurs to start up new businesses, something that you would think we would want to encourage?
Thank you for your question, Senator Van Hollen. I believe this strips away the pursuit of entrepreneurship because many young employees and young, hungry creatives are not in a position to negotiate for themselves. And they may agree to something at the time that sounds quite exciting and like the opportunity of a lifetime. But as sweat equity is put in and circumstances change, it can impact the way the contract is read. In my case, it was, in my opinion, it was weaponized. And one of the reasons I strongly believe they should be banned is that if you do allow some but not others, it still opens the gateway for litigation, which can financially ruin any individual, but it can also hurt small businesses and corporations. So I find that the solution to the problem is not through restriction or a scarcity mindset. It's through educating on other legal resources to protect your business, especially as a young entrepreneur looking to protect as you go, but not limit yourself.
Thank you. Really thank all three of you for your testimony. And Senator Warren, thank you for pulling together the hearing.
You bet. Thank you, Senator Van Hollen. Appreciate your coming by and asking these questions. So I just have one last question I want to take a look at. You listen to stories like Dr. Toussaint and Ms. Page, and you see it just seems so obvious that we should ban these and that we should not ask people to litigate them on, even when they've got a rule that looks like it applies to them. Let's just get rid of them overall. But right now, what we've got is a lawsuit, Jenning, in the Chamber of Commerce, and a handful of giant corporations are trying to sue the FTC to prohibit them from going forward with this ban. So, Dr. Scherholz, we've talked about whether or not there's really any legal basis for it. I think that the authorizing statute for the FTC makes pretty clear that the FTC can do this, but the Chamber of Commerce and these big corporations have done a little judge shopping, and they've gone down to this Trump appointee judge down in Texas and are trying to fight this. So my question to you is, why is the Chamber of Commerce, why are these big corporations spending so much money to try to block the ban on non-compete clauses?
It's because of who they represent. They represent business owners, and often very big business owners, and those are the ones who actually benefit from non-competes. They benefit because they can protect their position by keeping other people from being able to form business who then compete with them. They benefit because they can pay their workers less and prevent other businesses from being able to hire away their workers by offering them better jobs. So they are actually much better off with non-competes. And so it's totally reasonable why these business groups are fighting tooth and nail to keep their non-competes, but that does not mean that they're good for the economy, does not mean they're good for the country. They are not. They are bad for the vast majority.
Right. I think your point is a really strong point. It's not only that they want to be able to treat their workers however they want to treat their workers, and all the worker can do is just say, okay, I won't work at all. That obviously is not a solution. But that it's also a way for these giant businesses to make sure they don't have any competition, that the Haley Page wedding designs are not out there competing with whatever business they want to have in the wedding space, that Dr. Toussaint is not working with other doctors to provide alternative medical practice and an alternative approach to it, that the private equity group that set this up wants to continue to reap all the profits of a non-competitive market, and that's a key part of what's going on here. I just want to say again how much I appreciate your bringing this forward and telling these stories so that people who may not have ever had a non-compete clause, or worse yet, may actually be subject to a non-compete clause but will not discover it until the day comes that they want to go work somewhere else, or they want to start their own business, or they've got some terrific idea and want to link up with a couple of partners and go build something new, and discover that they're not able to do that. I so appreciate what the FTC and the Biden-Harris administration is doing to just level the playing field, to say that anyone who goes to work can go to work. We can have all the rules we need about not disclosing confidential information or taking someone else's intellectual property. But as for your own labor and how you want to work and what you want to do, that's open. And you can take that labor where you want to go and build what you want to build. That is the American way. So thank you very much for being here. I'm grateful to you for coming to this hearing. Questions for the record are due 1 week from today. That's Tuesday, August 6th. For our witnesses, if there are additional questions, you will have 45 days to respond to any of those questions. And with that, this hearing is adjourned.